Welcome back to the Deep Dive. Today, we are opening up a set of documents that, at first glance, appear to be the absolute driest instruction manual you could possibly imagine. We're looking at the Federal Rules of Civil Procedure.
Oh, boy.
Yeah. And specifically, we're diving into the rules around something called joinder.
It just sounds incredibly dry, doesn't it? Joinder of claims and parties. It sounds like plumbing instructions for a lawsuit. Like we're trying to figure out, how to fit pipe A into slot B.
That was my exact first thought when I saw the topic. I thought, oh, here we go. Pure technicality. But the more I spent time with these excerpts you sent over these sections on joinder of claims and parties, I realized that, plumbing is totally the wrong analogy.
Okay.
This isn't about pipes. This is about the guest list for the most high-stakes, expensive, and frankly chaotic dinner party on Earth.
That is a much, much better way to frame it. It really is all about who's in the room.
Because when we think about lawsuits, or at least when I think about them from, TV shows or movies, we have this very specific scene in our heads. One plaintiff, one defendant, one dramatic argument in some wood-paneled room.
Right. It's very clean.
Kramer versus Kramer. It's the people versus O.J. Simpson. It feels very one-on-one. But looking at these rules, real life, it just doesn't work that way, does it?
Rarely. I mean, almost never. Real life is messy. It's untidy. A car accident, a corporate merger that goes wrong, a defective product that, explodes. These events create a blast radius.
Right.
They don't just hit one person, they hit dozens. They don't just involve one law being broken. They involve contracts, torts, federal statutes, insurance policies, all at once. If the legal system only allowed one person to sue one other person for one specific thing at a time, the courts would just grind to a halt in like 20 minutes.
So the mission of today's deep dive is to figure out how the legal system organizes that mess. How do we decide who gets invited to the lawsuit? Who's allowed to, crash the party uninvited?
And who gets kicked out by the bouncer?
Exactly. And maybe most importantly, who gets stuck with the bill at the end of the night?
And to understand that, we have to look at these joinder rules. We're going to cover, I think, 4 distinct areas today to really make sense of this. First, we'll look at joining claims, which is basically the kitchen sink strategy of throwing every accusation you have at your opponent.
Okay.
Then we'll look at joining parties, so who can be there versus who must be there. Then third parties, the people who get dragged in kicking and screaming or who try to sneak in to protect their own money.
And then the big one.
And finally, yes, we will look at the blockbuster movies of the legal world. Class actions.
Before we really get into the weeds of, Rule 18 and Rule 20, I want to ask about the philosophy here. Because reading through this source material, I felt this constant tug of war. On one hand, the rules seem obsessed with efficiency. Just, let's solve everything right now.
Get it all done.
But on the other hand, they seem terrified of confusion, like, don't make this too complicated.
You have absolutely put your finger on the central tension of modern civil procedure. It is the eternal battle between efficiency and fairness. Efficiency argues that if we have a dispute, we should bring every related person and every related problem into one room and just solve it all at once. I mean, it saves tax dollars, it saves the judge's time, it saves witnesses from having to testify twice.
That makes perfect sense.
But fairness asks a completely different question. Is a jury actually going to understand a case with 50 different parties? Is it fair to drag a small subcontractor into a massive lawsuit that will bankrupt them in legal fees just because they're, tangentially related? The rules we're about to discuss are the compromise between those two forces.
Okay, let's start with the offensive strategy. I'm the plaintiff, I'm filing a lawsuit, and I want to look at joinder of claims, which falls under Rule 18. Now, before reading this, I assume that if I sue you, I have to sue you for a specific event. If you punch me in the nose, I sue you for the punch.
That's the intuitive way to think about it.
Right. But Rule 18a seems to just blow that idea completely out of the water.
It really does. Rule 18 is often called the kitchen sink rule for a reason. The text is incredibly permissive. It says a party asserting a claim may join as independent or alternative claims as many claims as it has against an opposing party.
As many as it has. That phrasing is just wild to me. So they don't even have to be related at all.
No relation necessary. They can be completely independent in nature.
Let's try to apply this to a hypothetical just to make sure I've really got it. Let's say I'm furious with my neighbor, Bob.
Okay, we got Bob.
Bob cut down my prize-winning oak tree because he said it was shading his pool. So that's a property dispute. It's a big one. I'm taking him to federal court because that tree was worth a fortune.
Oh, very valuable tree.
But as I'm getting the lawsuit ready, I also remember that, like, 3 years ago, I sold Bob a used ride-on lawnmower, and he never paid me the last $500 for it.
Ah, Bob.
Can I just toss the lawnmower debt into the big tree lawsuit?
Absolutely. You can pile both of those claims right into one complaint. You can sue him for the $80,000 tree, and in the very next paragraph, sue him for the $500 lawnmower.
Wow.
The philosophy is basically, look, we're already here. We've got the judge. We have the lawyers. Bob is already sitting at the defendant's table. Let us air all the grievances between these two people and settle all the accounts once and for all.
It feels incredibly efficient, but it also feels a little petty. Like, and another thing, you owe me for the lawnmower.
It might feel petty, but from the court's perspective, it prevents a second trial 6 months from now.
Mhm.
If you sued him for the tree and then next year decided to sue him for the lawnmower, the court would just roll its eyes and say, why didn't you handle this when you were here last time?
That brings up a really important point, though. The rule says I can join the lawnmower claim. But do I have to? Is there some kind of penalty if I decide not to?
This is where it gets a little tricky. Rule 18 itself, the text of the rule, is permissive. It says, may. So strictly speaking, you don't have to bring the lawnmower claim because it has nothing to do with the tree. They're factually unrelated.
Okay.
However, there's a hidden stick behind that carrot, and it's called res judicata, or what we call claim preclusion.
We've touched on preclusion and a few other deep dives, but can you explain how it sort of forces my hand here?
Sure. Res judicata essentially means the thing has been decided. It's the legal system's way of saying you only get one bite at the apple. So, if you have claims that are related, let's change the facts a bit. Let's say in addition to cutting down the tree, Bob also knocked over your fence during the same incident.
Okay, same with that.
Exactly. You absolutely must bring the fence claim now with the tree claim.
Because it's part of the same transaction or occurrence.
You got it. If you sue for the tree, win, and then try to file a new lawsuit for the fence next year, the court will say, stop, you should have brought that up in the first lawsuit. It arose from the same transaction. Case dismissed.
I see. So the lawnmower is optional because it's a totally separate event from years ago. But the fence is mandatory because it happened at the same time as the tree.
Precisely. But what this means in practice is that lawyers tend to be paranoid. They tend to over-include claims. They throw in the kitchen sink because they are terrified of accidentally waiving a claim they might need later on. It's just safer.
Better safe than sorry, I guess. Now, I saw something in the notes about Rule 18b and something called contingent claims. This sounded a bit like the movie Inception, like a claim within a claim.
It addresses a very specific but very practical nightmare, especially for creditors. Imagine you want to sue someone for money damages. Let's say they breached a business contract for $1 million.
Okay.
But you know this person is, well, dishonest. You know that the moment they get served with that lawsuit, they are going to transfer all their assets, their house, their cars, their bank accounts to their brother-in-law.
Right.
So that if you win the lawsuit, they can just shrug and say they're penniless and you can't collect a dime.
The classic hiding the assets maneuver. In legal terms, that's called a fraudulent conveyance, right? Exactly. Now, historically, under the old common law, you were stuck in a really terrible timeline. You had to sue for the money, go through the whole trial, win a judgment, then try to collect, fail because the accounts were empty, and only then could you file a brand new second lawsuit to set aside that fraudulent transfer. It took years. And by that time, the money's probably in the Cayman Islands or just gone.
Gone. So Rule 18b says, no, let's do this all at once. You can sue for the money and simultaneously sue to set aside the fraudulent conveyance in the very same complaint.
Wait, even though I haven't technically won the money yet.
That's the key, exactly. The second claim, the one about the assets, is contingent on you winning the first claim about the debt. But you can file them together. The court handles the logic. If you lose the debt claim, well, the asset claim just disappears because you're not owed any money.
But if you win?
If you win, the court can unwind that fraud right there on the spot. No need for a second lawsuit.
That is a massive upgrade in efficiency. It stops the shell game before it can even start. But I want to pump the brakes for a second here. We always have to talk about the gatekeepers. Just because the rule book says, hey, invite everyone, bring the lawnmower claim, that doesn't mean the federal court actually has the power to hear it, right?
Yeah.
We can't forget about subject matter jurisdiction.
You are so spot on, and this is exactly where law students often trip up on exams. Rule 18 is a procedural green light. It says you are allowed to do this, but jurisdiction is the road. You still need a road to drive on. Just because you can join a claim procedurally doesn't mean the court must take it. You still need subject matter jurisdiction for every single claim you bring.
Okay, so let's look at the math. If I'm in federal court based on diversity jurisdiction, so I'm from New York, you're from New Jersey, and the dispute has to be over $75,000,
Yeah.
how does this kitchen sink rule play with that dollar amount?
This is a huge, huge benefit for plaintiffs. If you are relying on diversity jurisdiction, a single plaintiff can aggregate. That means add up all of their claims against a single defendant to hit that $75,000 amount in controversy requirement.
Oh, wow. So let's go back to my neighbor Bob. Let's say my prize-winning oak tree is only worth $70,000.
Okay, which is below the threshold. If you sue just for the tree, the federal court would look at that and say, nope, not enough money, go to state court. They'd kick you out.
But he still owes me $6,000 for that fancy lawnmower.
You just add them up. $70,000 plus $6,000 is $76,000. Boom, you're in federal court. You can aggregate completely unrelated claims to pry open the doors of the federal courthouse.
That is a massive strategic tool, especially if you think a federal jury might be, I don't know, more sympathetic or maybe just give a bigger payout than a local state judge who might be golf buddies with Bob.
Precisely. It allows you to package a bunch of smaller disputes into one big federal case.
Okay, so that's the offense. I'm the plaintiff. I'm throwing the kitchen sink at you. But now we have to talk about the defense, the counterattack. The rules call this counterclaims and cross-claims, and it's under Rule 13.
And this is where the dinner party officially turns into a food fight.
Let's define the terms first. A counterclaim is basically, I'm rubber, you're glue, isn't it? I sue you, and you turn around and sue me right back.
In essence, yes. A counterclaim is a claim for relief that you make against an opposing party. It's usually filed in the defendant's answer to the complaint. And procedurally, you have to remember, if you get hit with a counterclaim, you are now a defendant on that issue. You have to file a reply, usually within 21 days, or you lose by default.
But the source material makes a huge distinction here, and it seems to be the most dangerous part of this whole game for a defense lawyer. The distinction between compulsory and permissive counterclaims.
It is the biggest trap for the unwary in the entire book of federal rules. It really is. Let's look at compulsory counterclaims first under Rule 13A.1. A counterclaim is compulsory if it arises out of the same transaction or occurrence as the original claim.
There's that phrase again, same transaction or occurrence.
It's the magic phrase of civil procedure. It basically just means the same real-world event. Let's create a scenario. Driver A runs a red light and smashes into driver B. Now, driver A maybe surprisingly sues driver B, claiming that B was speeding.
Okay, so A is the plaintiff, B is the defendant.
Right, but driver B was also injured in that same crash. His car was totaled. And driver B obviously blames driver A for running the red light. This claim by driver B, it arises from the exact same accident.
So it's compulsory.
It is compulsory. Therefore, driver B must countersue driver A in this specific lawsuit.
And what if driver B thinks, you know what, I'll just defend myself now. I'm busy. I'll sue driver A next year when I have more time to gather all my medical records.
Then driver B loses. Forever. The consequence is strict waiver. If you don't bring a compulsory counterclaim now, you are legally precluded from ever suing on it in federal court.
That seems incredibly harsh. Why force them to rush it?
Well, think about that efficiency argument again. We have the witnesses, we have the police reports, the diagrams of the intersection. They are all in the courtroom right now. The jury is learning the facts of this specific crash. Why on earth would the system want to dismiss that jury, send everyone home, and then start the exact same process from scratch next year, just with the roles reversed?
Yeah, that would be a huge waste of time and money.
It's a waste of public resources and judicial time. So the rule says, use it or lose it.
That makes sense from a taxpayer perspective. So that's compulsory. What makes a counterclaim permissive?
That's under Rule 13b. A permissive counterclaim is one that does not arise from the same transaction or occurrence. It's like your lawnmower example, but in reverse. If you sue me for the car crash and I say, hey, by the way, completely unrelated to the crash, you breached a contract to paint my house last year, that claim is permissive.
So I have a choice. I can bring it now or not.
Exactly. The defendant has discretion. You can bring it now if it's convenient, or you can wait and file a totally separate lawsuit later. You won't lose the right to sue by waiting because the evidence for the house painting has nothing to do with the evidence for the car crash.
Is there a jurisdiction difference here? I feel like the courts would have to treat these differently regarding their power to hear the case.
They absolutely do. Because a compulsory counterclaim comes from the same set of events as the main case, The court almost always has what we call supplemental jurisdiction over it. It gets to ride the coattails of the main case into federal court.
So it doesn't need to meet the $75,000 limit on its own.
Correct. But the permissive one, the house painting contract, that one is a stranger to the main case. It usually needs its own independent jurisdictional basis. So if that contract dispute doesn't meet the diversity requirements or federal question rules on its own, the court might say, sorry, this doesn't belong here. Go take that one to state court.
Okay, so that's fighting back against the person suing you. But what about friendly fire? The outline mentions cross-claims under Rule 13G.
Friendly fire is a good way to put it, or maybe fighting in the ranks. A cross-claim is a claim against a co-party. So if a plaintiff sues both Defendant 1 and Defendant 2, and then Defendant 1 decides to sue Defendant 2.
Why would they do that? Aren't they supposed to be on the same side defending against the plaintiff?
Usually, they're trying to shift the blame. Imagine a three-car pileup. The victim in the front car, the plaintiff, sues both drivers who hit him from behind. Driver A, the middle car, might file a cross-claim against driver B, the last car, saying, actually, this was entirely your fault. You hit me so hard, you pushed me into the plaintiff, you should pay the plaintiff, and you should pay for the damage to my car, too.
Okay. Now, is this like the compulsory counterclaim? If driver A doesn't sue driver B right now, does he lose the right forever?
No. And that is the key takeaway for cross-claims. They are never mandatory. Even if it arises from the very same crash, you can always choose to sue your co-defendant later in a separate action. The rule says a party may state a cross-claim, but it never, ever says must.
That's a relief. It allows the defendants to, present a united front if they want to, without being forced to stab each other in the back right away.
Exactly. Sometimes the best strategy is to stay friends, at least through the main trial.
Okay, we've covered the claims, all the arguments being thrown around. Now let's look at the actual people, the guest list itself. Joinder of parties. This is Rule 20 and Rule 19.
Right. And just like we saw with claims, we have permissive guests and we have compulsory guests.
Rule 20 deals with permissive joinder. So this is when plaintiffs want to team up or when a plaintiff wants to sue a whole group of people together. What's the test for this? When are you allowed to form a squad?
There's a two-prong test, and you have to meet both prongs. First, all the claims for relief must arise out of the same transaction, occurrence, or series of transactions. And second, there must be a question of law or fact common to all the parties.
Let's apply that to a really clear example, a bus crash.
Perfect. A city bus crashes, 10 passengers are injured. Now, each passenger has a separate injury. One has a broken leg, one has whiplash, another has a concussion. Those are individual damages.
Right.
But all of their injuries arose from the same single occurrence, the crash. And there will be a huge common question of fact. Was the bus driver negligent?
So instead of 10 separate lawsuits, all trying to prove the same thing, all 10 passengers can join together as plaintiffs in one big lawsuit against the bus company.
Correct. That's Rule 20A1. It's incredibly efficient. We answer the was the driver negligent question one time for everyone. If we did it in 10 separate trials, one jury might say, yes, he was negligent, and another jury down the hall might say, no, he wasn't. That kind of inconsistency is really bad for the legal system.
But here is where the source material points out a massive, massive trap. The jurisdiction gotcha. The notes mention Section 1367B and the ExxonMobil case. This seems like a mathematical puzzle designed to break law students' brains.
It is a logic puzzle, and it's very tricky. So remember, in diversity cases, generally every plaintiff needs to be from a different state than every defendant, and every claim needs to be for more than $75,000.
Right, the basic rules.
But what if you have multiple plaintiffs joining under Rule 20? Suppose Plaintiff 1 has a really serious injury, a claim for $200,000, well over the limit. But Plaintiff 2, who was in the same crash, only has a broken arm that's worth, say, $25,000. Can Plaintiff 2 ride along?
Intuitively, I'd say yes. It's the same crash. Why kick them out over the money part?
And the Supreme Court agrees with your intuition. In a case called ExxonMobil v. Alapata Services, the court said yes. As long as one plaintiff meets the amount requirement, the others can tag along under supplemental jurisdiction. The door is open for them.
Okay, that sounds friendly. Very efficient.
But wait, now let's flip it. What if one plaintiff sues two defendants under Rule 20? Let's use the example from the text. A plaintiff from Arizona gets into a car wreck with driver 1 from New Mexico and driver 2 from Nevada.
Okay, so everyone is from a different state. Diversity of citizenship is fine.
Correct. The plaintiff sues driver 1 for $100,000. That claim is fine. but he sues driver 2 for only $25,000 of damage. Can he keep driver 2 in the federal case?
Based on the Exxon case and the whole idea of efficiency, I'd want to say yes again.
And you would be wrong.
Ah, why? Why the double standard? That makes no sense.
Because Congress, in a statute, Section 1367B, specifically wrote a rule that strips away supplemental jurisdiction for claims against defendants joined under rules like Rule 20 in diversity cases.
That seems so arbitrary. What's the logic behind that?
The courts are terrified of plaintiffs artificially manufacturing federal jurisdiction. They don't want a plaintiff from New York to sue a big, diverse corporation from California and then use that as an excuse to drag in a bunch of small, local New York defendants just to clutter up the federal docket. So in that car crash scenario, the claim against driver 2 gets dismissed. We call it the poison pill defendant scenario. The small claim against that second defendant ruins the supplemental jurisdiction for that specific claim.
That is a headache and a half. So, okay, Rule 20 is about who can join. Rule 19 is about who must join, compulsory joinder. This is when the court looks at the dinner table and says, we can't eat dinner until Uncle Bob gets here.
That's a great way to put it. We call them necessary parties. The test under Rule 19A asks 3 questions to determine if someone is necessary. 1. Can we give complete relief to the existing parties without this person? 2. Will the missing person's own interest be harmed if we proceed without them? And 3, will the existing parties be at risk of double obligations if we leave this person out of the lawsuit?
And if the answer to any of those is yes, they are necessary, and the court orders them to be joined. But I noticed a huge exception in the source material regarding joint tortfeasors. This seems like a critical strategic point for plaintiffs.
Yes, this comes from a big Supreme Court case, Temple v. Synthescore. A joint tortfeasor is just a fancy legal term for one of several people who helped cause the harm.
Like in a medical malpractice case, it could be the surgeon and the hospital.
Right. And that was close to the facts in Temple. A man had a metal plate implanted in his back. The screws broke. He sued the manufacturer of the device. The manufacturer's lawyers said, hey, wait a minute. You have to join the doctor who did the surgery and the hospital where it was done. They might have messed up the surgery.
That sounds like a classic Rule 19 argument. We can't resolve this without the doctor in the room.
You'd think so, but the Supreme Court said no. It is a long-standing principle of tort law that a plaintiff does not have to sue all joint tortfeasors in the same lawsuit. You, the plaintiff, are the master of your complaint. If you want to sue just the manufacturer because they have the deepest pockets and leave the local doctor alone, that is your right. The doctor is not a necessary party under Rule 19.
That seems to really favor the plaintiff's autonomy over total efficiency.
It absolutely does. It prevents the defense from cluttering up the case with a bunch of other parties just to try and dilute the blame or confuse the jury.
But what happens if there is a truly necessary party? Let's say you're fighting over a patent and you absolutely need the owner of the patent there, but they cannot be joined. Maybe joining them would ruin diversity jurisdiction because they're from the same state as the plaintiff.
Then we enter what's called the equity and good conscience phase. This is Rule 19B. The court has to make a very tough call. Do we limp along without this key person, knowing the result will be imperfect, or do we dismiss the entire case because it's just not fair to anyone to proceed without them?
So sometimes the guest list is so messed up you just have to cancel the whole party.
Precisely. If that missing party is deemed indispensable and cannot be joined, the case dies in federal court. You have to go find a state court that has jurisdiction over everyone.
Okay, moving on to segment 4. The third wheels. These are the parties that weren't on the original invite list at all. Let's start with intervention under Rule 24. This is the party crasher.
Crasher implies they're unwanted, but, sometimes they are desperately needed to protect their own rights. Rule 24 splits this into 2 types: intervention of right and permissive intervention.
Intervention of right sounds intense, like I have a right to be here.
It is. To intervene as of right, you have to show that you have a legal interest in the subject of the suit, that the lawsuit might harm or impair that interest, and, this is the crucial part, that the existing parties are not adequately representing your interest.
So, for example, if I'm an environmental group and the EPA is being sued by a big factory to lower emission standards, I might try to intervene in that lawsuit.
That is the classic example. The factory wants to pollute more. The EPA is defending the regulation. But you, the environmental group, might think, the EPA might settle too easily. They won't fight as hard as we would. We need to be in that room to make sure our arguments are made correctly. If you can convince the judge that the EPA's representation is inadequate, The court must let you intervene to defend the regulation yourself.
Then there is interpleader, Rule 22. This one confused me a bit until I read the stakeholder concept. This is about someone who is just holding the bag, right?
It's about someone holding the money who is terrified of paying it to the wrong person and then getting sued again. The classic textbook example is a life insurance policy.
Yeah.
A man dies, he has a $100,000 policy. His ex-wife shows up and claims she's the beneficiary. His current widow claims she is the beneficiary. And then his business partner shows up and claims the policy was signed over to him as part of a deal.
And the insurance company's just sitting there thinking, I have $100,000, I'm happy to pay it, but if I pay the widow, the ex-wife will sue me. If I pay the ex-wife, the partner will sue me.
Exactly. They are facing what the rule calls double or multiple liability. So interpleader allows the insurance company, the stakeholder, to sue all the claimants at once. Basically, they file a lawsuit, throw the money on the court's table, and say, you guys fight it out, tell us who wins, and we're out of here. It gets them off the hook.
Now, the sources mentioned there are two ways to do this. Rule 22, interpleader, and statutory interpleader. And the statute seems like a massive shortcut that Congress created.
It is, and it's the preferred route for most companies because the jurisdiction requirements are so incredibly relaxed. Under the interpleader statute, Section 1335, the amount in controversy only needs to be $500.
$500, not the usual $75,000.
Nope, $500. And even better for the stakeholder, you only need minimal diversity. That means you just need any two of the claimants to be from different states. The insurance company's own citizenship doesn't even matter.
Wow.
Congress did this intentionally. They wanted to make it very, very easy for companies to resolve these messy disputes in one federal court rather than having to fight 3 different lawsuits in 3 different state courts.
I like that. That's the legislature saying, we know this is a mess, so let's make it easy to fix. Next step is impleader under Rule 14. This is the it was him rule.
This is when a defendant decides to bring in a third person to pay for some or all of the liability. The key words you'll hear are indemnification and contribution.
The text uses a construction example, which seems pretty clear.
Right. Let's flesh that out. A general contractor, the GC, gets sued by a homeowner because the new roof leaks and has ruined all the expensive hardwood floors. The GC says, wait a minute, I didn't hammer those shingles myself. I hired a specialized roofing subcontractor to do that work. So the GC uses Rule 14 to implead the subcontractor.
And the argument is basically, if I am found liable and have to pay the homeowner, the subcontractor has to pay me back.
Exactly. It's a chain of liability. The subcontractor is brought into the lawsuit as the third-party defendant. Now, note that the GC isn't saying, I'm not liable to the homeowner. He's saying, if I'm liable, it's because of this guy, and he has to reimburse me.
And there was a weird geography rule here that really caught my eye, the 100-mile bulge. What on earth is that?
It's a quirky but useful exception to how far you can reach to serve court papers. Usually, you're limited by state lines and what are called long-arm statutes. But for impleader and also for bringing in necessary parties, the federal rules give you a bulge. You can serve these third parties anywhere within 100 miles of the courthouse, even if that 100-mile circle crosses into a neighboring state.
So if the federal court is in Manhattan, you can serve papers on someone in Jersey City or Stamford, Connecticut, if they're within that 100-mile radius, just to make sure this whole third-party mess gets sorted out in one go?
Correct. It's a recognition that economic zones like the tri-state area don't respect state lines, and it's inefficient to block impleader just because the subcontractor happens to live across the river.
All right, we have arrived at the final segment, the big one, the blockbuster. Class actions, which is Rule 23. This is when one person stands in for hundreds or thousands or even millions.
These are the blockbuster cases. Instead of Joinder, where we list every single name, we have a representative who sues on behalf of a class. And this is often the only way for small claims to ever get justice. You know, if a bank illegally overcharges 100,000 people by $20 each, no one is going to sue individually. It costs more to file the suit than the claim is even worth.
So the class action bundles them all together. But you can't just stand up and declare, I am the voice of the people. You have to prove it to the judge. The source lists 4 prerequisites under Rule 23A. I came up with a mnemonic for it, NCTA.
I like that. Walk us through them. These are the 4 hurdles every single class action lawyer must jump over to get the case certified.
Okay, first is N for numerosity.
Which just means the class is so large that joining them all individually, like we do in Rule 20, is impracticable.
Yeah.
You know, if you have 20 people, you can probably just join them. If you have 4,000 people, you need a class action. As a rule of thumb, courts usually look for 40 or more members as the tipping point.
Second is C for commonality.
There must be questions of law or fact that are common to the whole group. We are all fighting about the same defect in the same model of car. Or we all were subjected to the same discriminatory policy.
Third is T for typicality.
The representative's claim has to look like everyone else's claim. The lead plaintiff's story has to be typical of the group's story. You can't have a representative with a wildly unique situation leading the charge because their unique problems will distract from the common class issues.
And finally, A for adequacy.
This is a big one. The court has to check if the representative, and maybe more importantly, their lawyer, will fairly and adequately fight for the whole group. They can't have any conflicts of interest. For example, the class representative can't be the brother of the CEO of the company that's being sued.
Okay, so once you pass those 4 hurdles, you're still not done. You have to fit into one of 3 types of classes under Rule 23B.
Right. And type 1 is pretty rare. It's usually used for what's called a limited fund. Like, the company that caused the harm only has $1 million in assets, but there's $10 million in claims. If we let people sue individually, the first 3 people to get a judgment get paid, and everyone else gets 0. So we group them all together to share the pain or the fund equally.
Okay. Type 2 is for injunctive relief.
This is for changing behavior, not for getting cash. Civil rights cases are the classic example here. We want the court to issue an injunction, an order telling the school district to desegregate. We aren't looking for individual checks for each student. We are looking for a single, powerful remedy that applies to everyone.
The text mentioned the big Supreme Court case, Ramarda v. Dukes here. That was a massive gender discrimination case.
Yes. And that case clarified that you can't use a Type 2 class to ask for individualized money damages. If what you really want is back pay that's different for every single employee based on their history, you can't shoehorn that into an injunctive class just because it's easier to get certified. The Supreme Court shut that down, saying you need individualized hearings for that kind of money damage.
Which leads us to the big money class, Type 3, the damages class.
This is Rule 23b3, the common question class. This is every consumer product defect case you've ever heard of. To get this type of class certified, you have to show 2 extra things: that the common questions predominate over the individual ones, and that a class action is the superior way to handle the dispute.
And because these cases can get so huge, so national, Congress stepped in with CIV, the Class Action Fairness Act of 2005. Why was this necessary?
Well, before 2005, lawyers were filing these massive nationwide class actions in tiny, friendly state courts. Some people called them judicial hellholes, where local judges would certify almost anything. Congress realized this was potentially unfair to interstate businesses, so CAFA makes it very, very easy to move these big cases out of state court and into federal court.
What's the threshold for the feds to take over the case?
If there are more than 100 members in the class and there's over $5 million at stake in total, the case can be moved to federal court. And the diversity rule is relaxed to minimal diversity. You just need one plaintiff to be from a different state than one defendant. It basically nationalized the biggest and most important lawsuits in the country.
Finally, we have to talk about how these cases end. Settlement. In a normal lawsuit, if I want to settle with my neighbor Bob over the tree, we just shake hands, sign a paper, and go home. The judge doesn't care. But in a class action,
The judge cares deeply. Under Rule 23E, the court must approve any settlement. They hold a fairness hearing to make sure the deal is fair, reasonable, and adequate for the class members.
why the babysitting? Why does the judge have to get involved?
Because of what's known as the principal agent problem. The lawyers representing the class, the agents, have a huge incentive to settle the case for a big, fat legal fee for themselves, even if the class members, the principals, only get a coupon for $5 off their next purchase. The judge acts as a fiduciary, a guardian, for the absent class members to make sure they aren't getting sold out by their own lawyers.
And part of that protection is the notice and the right to opt out.
A crucial point of due process. In a damages class, a Type 3 class, the court must make sure the members are notified, usually by mail or email. Hey, you're a part of this lawsuit. And they must give those people a chance to opt out. To say, thanks, but no thanks. I want to sue on my own.
And if I get that notice postcard and just throw it in the trash and do nothing,
Then you are in, and you are bound by the result, win or lose. If the class loses, you lose your right to sue. You can't try again on your own later. This was decided in a case called Phillips Petroleum Co. v. Schutz. Your silence equals consent, provided you got the notice.
wow. It really is a tangled web we weave. We've gone from a dispute over a $500 lawnmower to a multi-million-dollar class action involving thousands of people.
It's the architecture of modern justice. It has to be complex to handle complex problems.
So, to bring it all home, what does this all mean for us? What's the final synthesis?
I think it goes right back to that tension we started with. You have rules like 13 for counterclaims and 14 for impleader that are just obsessed with efficiency. Their whole purpose is to clean up the entire mess in one room. And you get in here right now. Let's settle this.
But then you have rules like 19 for compulsory joinder and 23 for class actions that seem to be more about due process.
Exactly. Their focus is on fairness. They're constantly checking. Is the right person here? Is the absent person's interest being protected? Is the little guy getting proper notice and a chance to be heard? It's a constant balancing act between speed and rights.
It's fascinating. It really turns the courtroom from a simple boxing ring into I don't know, a chaotic town hall meeting.
A town hall meeting with very, very strict rules of order.
So leave us with a final thought to chew on.
We talked a lot about all these rules that are designed for efficiency, but notice just how complex they are. The 100-mile bulge, the supplemental jurisdiction exceptions, the different math for Rule 20 defendants versus Rule 20 plaintiffs. At what point does the overwhelming complexity of the procedure actually prevent a regular person from getting justice? If you need to hire a team of expensive lawyers just to figure out if you're allowed to invite the subcontractor to the lawsuit, is the courthouse door truly open to everyone?
That is a heavy question. Complexity itself as a barrier to entry.
It's something to think about next time you see one of those class action notices in your mail or hear about a big lawsuit in the news.
Thanks for listening to The Deep Dive. Next time you hear about a lawsuit, look for the hidden parties. There's always more than meets the eye. See you next time.